One measure the governor signed earlier this year facing legal challenges over the Second Amendment. That, of course, is the gun and magazine ban and the gun registry. Still anticipating litigation challenging the law based off of Fifth Amendment grounds. But you've got other laws the governor enacted facing litigation concerning the First Amendment. And this deals with the states being able to go after pregnancy centers that don't offer abortion services. And a federal judge last week issuing a preliminary injunction against that law the governor signed last month. And the arguments are First Amendment arguments. This as we await for the governor to enact House Bill 218, which could lead to another set of litigation challenging state law based off of First Amendment grounds. So let's get into this. It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And the headline, of course, federal judge temporarily blocks a law aimed at deterring deceptive anti-abortion practices, calling it both stupid and very likely unconstitutional. So this is a fascinating play here in the federal courts in the Northern District. And if we go to the docket of this case, which is National Institute of Family Life Advocates versus Kwame Raoul, and we see this case that was filed in federal court seeking a temporary restraining order, preliminary injunction, and the Thomas More Society, the one driving this. And you look at the docket, and the case was filed on July 27th. That complaint was made. Then you get all the appearances being made and the motions being made. What's fascinating here is, though, you get to earlier this month and a motion that was made from the Kwame Raoul defense as the Attorney General. They actually had looked to possibly delay things. So you had a motion for a extension of time to file. And this was, of course, the motion from Kwame Raoul's office, the Attorney General's office on August 3rd, a motion for an extension to file a response. But then the judge issued what's called a minute on the docket, and it said that the motion is meritless on many levels, too many to explain in a minute order. Defendant has been given timely notice of the hearing and was served last week. This lawsuit should not come as a surprise to the defendant. So again, saying that the state shouldn't be surprised that this law was going to be challenged. Any standing concerns or any other jurisdictional issues can and will be addressed at the hearing. So they then had a hearing. And at the hearing, both sides had their say, and then ultimately the judge during the hearing issued a preliminary injunction. Then you get that preliminary injunction ultimately released on Friday late, where that order was issued. So here we are now. We've got the judge essentially saying that the law is both stupid and very likely unconstitutional, and a blatant example of government deciding whose speech is sanctionable and whose speech is immunized. This is a law that the governor signed, right, at the behest of the Attorney General, a year after Roe v. Wade was essentially overturned and the decision of abortion regulation being put back onto the states. The judge in this case said that the law is likely classic content and viewpoint discrimination prohibited by the First Amendment. So Governor JB Pritzker reacting to the judge halting this, and at an unrelated news conference on Friday, he provided his reaction. Saying that, he still stands by the law and hopes that the judge and the courts ultimately allow for this law to stay in place. Here's the governor.
Well, obviously, we'll wait to hear what the final ruling is. This was a TRO ruling, as you know. But I think it's reasonably clear we have laws in place that deal with deception, misinformation, and this is an extension of that to make sure that people are not misinformed when they're coming to a facility to exercise their reproductive rights. As I have mentioned before, the Attorney General was on his way to a Planned Parenthood facility himself, when he was stopped coming into the parking lot by somebody representing one of those centers that's trying to divert people away, and felt that he was being fed misinformation. And the result of that was he came back to the legislature and said this shouldn't happen, especially to a woman who's just seeking to exercise her rights, and wanted to make sure that there was no deception involved. Again, these organizations are allowed to communicate to people who are on their way, but they're not allowed to deceive them according to this law. And I hope that the federal courts will recognize that you can't lie to misinform people and send them in a direction that they're not fully aware that you're changing the direction of what they're trying to accomplish.
So again, the governor saying that he hopes the federal courts look at the law and say that it's not a violation of the First Amendment free speech. But that seems to be the crux of what's behind this. You had the preliminary injunction issued, and the plaintiffs in this case praising that, saying that this is a free speech victory. Pro-life advocates across Illinois can breathe a sigh of relief. They won't be pursued for misinformation by Attorney General Kwame Raoul. And that's from Peter Breen, the executive vice president and head of litigation for the Thomas More Society, and a former Republican state representative. They went on to say that other pro-life organizations say that the injunction restores real choice to women facing untimely pregnancy, and a chance at life for their unborn child. So these are obviously some of the reactions before the judge issued that ruling. Peter Breen, he kind of gave just an overview of how simple the arguments are about this being a free speech issue when it comes to being able to go after individuals who may say one thing or another. Here's Peter Breen.
The First Amendment is for everyone, and free speech declares that means that government should not be telling you what is true or false on an issue of significant public debate.
And he further said that the free speech argument, it should be sustained.
There's also free speech principles that you can't target people based on their positions. So in this instance, they're solely targeting the pro-life view.
So this case continues. It's a preliminary injunction, essentially putting the law on hold so the Attorney General cannot go and enforce this law against, crisis pregnancy centers that give people options other than abortion when it comes to an untimely pregnancy. So obviously this case is going to continue. Who knows if the Attorney General is going to appeal that decision of a preliminary injunction to the appeals court, or if they just say, all right, let's litigate this. So we'll be watching that case closely, dealing with the First Amendment, because you got other cases that could possibly come up, including a First Amendment challenge to whether or not the states can go after gun manufacturers for certain types of advertising. And whether or not that's going to run afoul of the First Amendment. So maybe this case against the states over being able to go after pregnancy crisis centers could be a bellwether for how the federal courts will view other laws, such as the law that it's not a law yet, still a bill on the governor's desk about House Bill 218 and whether the state can go after gun manufacturers. All right, so a lot going on there in federal court, just to keep you updated on all of that, and we'll be watching closely.